Framework 2.1, Canadian Constitutional Law. The importance of a Constitution. The Constitution of a state embodies its values and dictates the structure of its government and its legal system. In Canada, this includes the division of powers between the federal and provincial governments, the processes involved in passing laws, the structure of the courts, and the protection of individual rights. Sources of Canada's Constitution. There are three main sources of Canada's Constitution: the written Constitution contained in acts and all amendments to these acts, the unwritten conventions by which our government operates, and the court decisions that interpret the written Constitution or legitimize the unwritten Constitution. Canada's written Constitution. The British North America Act, 1867, united the provinces of Upper and Lower Canada, now Ontario and Quebec, New Brunswick and Nova Scotia, and created the country of Canada. Although drafted by the Canadian Fathers of Confederation, it was an act of the British Parliament. All subsequent amendments to the Constitution also had to be passed by the British legislature until 1982, when the Constitution was patriated by the passage of the Canada Act 1982, which contained the Constitution Act 1982 and changed the name of the British North America Act 1867 to the Constitution Act 1867. The Constitution Act 1982 is now the primary constitutional document in Canada. It incorporates the Constitution Act 1867 and the Canadian Charter of Rights and Freedoms, and includes a formula for future amendments to be made in Canada. In total, the Constitution Act 1982 is comprised of the following 7 parts. Part 1, Canadian Charter of Rights and Freedoms. Part 2, Rights of the Aboriginal Peoples of Canada. Part 3, Equalization and Regional Disparities. Part 4, Constitutional Conferences. Part 5, Procedure for Amending Constitution of Canada. Part 6, Amendment to the Constitution Act 1867. And Part 7, General. A federal system of government. The Fathers of Confederation chose to adopt a federal structure for the Canadian government in order to accommodate the diverse needs of the citizens in different parts of the country. The federal government retained power over national concerns such as defense and economic development, but the provincial governments were granted powers that were best administered on a smaller scale, such as education. Canada's unwritten constitution. Many rules or conventions that have been followed by the Canadian government to the point of being legally binding were not written into the Constitution. However, the Constitution Act 1867 stated that the Constitution would be similar in principle to that of the United Kingdom. Many constitutional conventions were therefore adopted because they had been long-standing traditions in Britain, such as the role of the Prime Minister, the formation of cabinet, and the party system. A more specific convention adopted from the British parliamentary system is that of cabinet solidarity. This dictates that a cabinet minister must resign if he or she disagrees with a decision of the cabinet. Court decisions. When there is disagreement over the interpretation of any part of the Constitution, the courts are called upon to settle it. These court decisions then become part of the country's constitution and are therefore binding on the government. The division of powers. The Constitution Act 1867 lists the specific powers that would be granted to the federal and provincial governments in sections 91 to 95. The powers that were considered most critical to the success of the country were made federal, such as those related to the economy, the postal service, and national defense. It was assumed that the provinces would be somewhat dependent upon the federal government in those areas. The provinces were granted powers of a more local nature, such as hospitals, municipal works and institutions, and property rights. Governments must be careful to pass legislation that is intra vires, which means within their powers. Otherwise, courts may find the legislation ultra vires and strike it down.
The importance of education. Control over education was considered vital at the local level, since it was believed that it was essential to preserving local culture for future generations. It was very important, for example, to the Francophones in Quebec, that the language of instruction was French, and that the schools would remain under the control of the Roman Catholic Church. The Constitution Act 1867 entrenched the rights to both Protestant and Roman Catholic education as they existed at the time. The funding of Catholic separate schools is still constitutionally guaranteed today, despite the arguments of other religious groups that it is unfair. The Charter, for example, cannot be invoked to determine separate school funding unconstitutional, since it is contained in the Constitution. The municipal level of government. At the time of the drafting of the Constitution Act 1867, very few people lived in cities, and municipal affairs were made the responsibility of the provinces. The provinces then gave very limited powers to municipalities, whereby they could pass bylaws and raise revenue through property taxes. Today, over 75% of Canadians live in urban areas, and some cities have populations that are much greater than some provinces. However, it is arguable that cities are in a very difficult situation of having limited powers to deal with very large and complex responsibilities. The role of the courts. With respect to the Constitution, the courts may be called upon to interpret its provisions, which may include the sometimes very difficult task of deciding which level of government has jurisdiction over a particular subject matter. When the British North America Act came into force in 1867, many powers which would be considered of the utmost importance today were not listed. For example, government control over health care and unemployment insurance was not anticipated until the time of the Great Depression of the 1930s, when the overall role of the government was reconsidered in a philosophical way. Also, advances in transportation and telecommunication, such as air travel and the internet, were certainly not on the radar. When new types of responsibilities arise and become evident, it is up to the courts to interpret the Constitution in order to decide which level of government will take them on. The structure of the courts. The Constitution dictates the hierarchical structure of the court system, which was based on the British system. The Supreme Court of Canada is the top level, where appeals are heard from three separate court systems: the federal court system, the provincial court systems, and the military court system. The federal court system has jurisdiction over some strictly federal matters. The provincial court system is much larger and more complex, and has jurisdiction over provincial matters as well as some federal matters such as criminal law and divorce. For some of these provincially administered federal matters, the cases will be heard in provincial courts by federally appointed judges. In this way, the federal government is able to retain some level of control. The historic role of the JCPC. Prior to 1949, there was an additional level in the court hierarchy above the Supreme Court of Canada, the British Judicial Committee of the Privy Council. The JCPC was responsible for many important constitutional decisions. It tended to define federal powers narrowly and expand the role of the provincial governments, which would have long-lasting effects on the Canadian political system. The JCPC is also remembered for overturning the Supreme Court of Canada's ruling in the Persons case of 1929. The JCPC found that females were indeed included in the meaning of persons in the BNA Act and could therefore be appointed to the Senate. The first female senator was appointed soon afterward. This decision is considered a landmark case in the advancement of women's rights. The Supreme Court of Canada. The BNA Act gave Canada the power to create a general appeals court, but the Supreme Court of Canada was not in fact created until 1875. Until that time, appeals would go directly from the provincial courts to the JCPC. Between 1875 and 1949, the Supreme Court of Canada was the second last possible forum for appeals, as the JCPC in Britain could still hear appeals. Since 1949, the Supreme Court of Canada has been the last court of appeal in Canada. The Supreme Court of Canada has the power to decide which cases are brought before it. This is called granting leave to appeal. There are 9 justices of the Supreme Court of Canada, appointed by the federal cabinet. By convention, 3 of them come from Ontario, 3 come from Quebec, 2 come from the Western provinces, and 1 comes from the Atlantic provinces. This distribution is based on population, but also on the fact that there must be 3 justices from Quebec in order to provide expertise in its civil code. The evolution of Canada's Constitution. When the British North America Act came into effect in 1867, Canada was part of the British Empire. This meant that any amendments to the BNA Act had to be passed by British Parliament. This had 2 important consequences. Firstly, Canada was bound to follow British law and foreign policy. For this reason, when Britain declared war on Germany in 1914, Canada was automatically at war as well. The second consequence to British constitutional authority was the fact that the final court of appeal in Canada's legal system actually resided outside of the country with the British JCPC. World War I. The First World War actually had an important impact on Canada's international position as a nation. By the time the Treaty of Versailles was signed in 1919, due to its tremendous contributions and sacrifices, Canada was allowed to sit at the bargaining table and sign the treaty in its own right. The Balfour Report and the Statute of Westminster, 1931. In 1926, a committee that had met at an imperial conference declared that the dominions of Britain would no longer be subject to its legislative authority. This declaration was contained in a document called the Balfour Report, and later passed into law with the Statute of Westminster, 1931. This meant that Canada was no longer subject to British laws and could pass its own laws that contradicted them. It also meant that Canada was no longer required to adopt British foreign policy. This was demonstrated when Canada declared war in World War II in its own right, a full week after Britain. Patriation of the Constitution. Despite the independence achieved with the Statute of Westminster, Canada's Constitution remained a British statute for over 50 more years. One reason for this long delay was the inability of the provinces to agree to an amending formula, which would be followed when future changes to the Constitution were required. When Prime Minister Trudeau was building his case for constitutional change in the early 80s, another controversial issue arose, that being the entrenchment of a Bill of Rights in the Constitution. When the Constitution was finally patriated in 1982 and renamed as a Canadian statute, the Constitution Act 1982, it did include an amending formula as well as the Canadian Charter of Rights and Freedoms. However, the Constitution Act 1982 had only been agreed to by 9 out of the 10 provinces. Quebec, which had complained that some of its concerns had not been addressed, refused to sign the agreement. The Meech Lake Accord. When Brian Mulroney became Prime Minister in 1984, one of his goals was to amend the Constitution to win the approval of Quebec. The government of Quebec proposed a number of changes, including the recognition of Quebec as a distinct society, and the expansion of provincial powers such as the right to nominate candidates for the Senate and the Supreme Court of Canada. All of the provinces were on board and agreed to a set of changes called the Meech Lake Accord, which was then passed by Parliament. However, the final step in the constitutional amendment was ratification by all of the provincial legislatures within 3 years. Largely due to criticisms about the dangers of giving Quebec special status and the fact that Aboriginal concerns had not been addressed in the Accord, it was not ratified in either Manitoba or Newfoundland by the deadline of June 23, 1990. The Charlottetown Accord. In 1992, Prime Minister Mulroney tried once again to create a constitution to which Quebec would agree. His progressive conservative government proposed changes that again included the expansion of provincial powers and also addressed many Aboriginal concerns. The Charlottetown Accord suffered a similar fate to Meech Lake. It was defeated in 6 provinces and 1 territory, demonstrating the great challenges involved in amending the country's constitution. The separatist movement in Quebec. The failure to amend the Constitution in a way that would address Quebec's concerns were just examples of a longer history of discontent in the province. There have always been those who desire greater control over the protection and growth of the French language and culture. In recent history, there have been 2 referenda in the province on the question of separating from the rest of Canada. In 1980, the Parti Québécois, government of René Lévesque, held a referendum on sovereignty association, which would give Quebec independence in all areas of lawmaking, but would maintain an economic association with the rest of Canada. The No side won this referendum by a wide margin. Following the defeat of the Meech Lake and Charlottetown Accords, the Parti Québécois was returned to power in Quebec under the leadership of Jacques Parizeau. A second referendum took place in 1995, this time on sovereignty, which would have meant a greater separation from the rest of the country than sovereignty association. The No side won again. However, the margin of victory was much narrower this time. The No side won just 50.56% of the vote. These issues had obviously not yet been resolved.